Welcome to another episode of the SERMAPod, which is the podcast for the Sports and Entertainment Risk Management Alliance. I'm your guest host, Matt Liller, filling in for Rich Linkov, who will be back next week. I'm an attorney in Roanoke, Virginia, a SERMA member, and I'm actually the longtime producer of the SERMAPod. But I'm even more excited to welcome today's guest. Professor Gil Fried is from the University of West Florida's College of Business, where he's also an interim assistant dean. He's an expert in sport risk management and facility management, having authored over a dozen books widely used in the industry, and he's published over 400 articles on facility law. We're very pleased to welcome Professor Fried to the SERMAPod. Welcome, Professor.
Thank you, Matt. It's a pleasure to be here. And what that introduction just indicates is I'm old. I've been doing this for a while.
Well, you're an expert. You've got some tenure behind you. So, Professor, risk to spectators at sporting events or concert venues is certainly not a novel topic or anything new. We've got a lot of people in a smaller, somewhat confined space, perhaps already divided by team allegiance and perhaps under the influence of some alcohol. When it comes to spectator risk, what are some of the more common types of incidents that you've seen in your career studying and covering this field?
So, we often take a look and see what makes the news, the scintillating videos and stuff like that really get our ire up, that we're really upset of what's going on. But the typical things that we often see are the standard trip and fall, slip and fall kind of cases. There are some areas where we've seen a little bit of a change. For example, foul ball cases. The number of foul ball cases has been decreasing in part because of enhanced netting that's been put up at Major League Baseball ballparks as well as minor league ballparks. But we're still seeing those type of cases coming up with little league fields and high school fields and some college fields. I was just highlighted in a decision in California where the court highlighted my report, I think like 12 times in their decision, dismissing the summary judgment motion. This was a plaintiff case for foul ball and indicating that there are facts that come into play that need to be analyzed. So we still have those standard kind of issues. The things that I think we see that are ones that people really jump out of their seat on are things such as like railing cases. I've handled a number of cases involving people falling over railing. And so while you have a building code that's out there, and the building code says you should have 42 inches at times, it says should have at certain times 36 inches. There's a number of different amounts that are out there. There is something called the line of sight exemption, which allows you to have 26 inches of railing height at certain areas where people are watching what's going on. Now, this was developed back in the 20s when you had dinner theaters and people were sitting down. In those same venues that are using that 26-inch exemption, you have now people with alcohol, people dancing, and people are taller now than they were back then. So center of gravity causes a concern for people because they could fall over. And in fact, I've handled several death cases and also serious injury cases of people falling over railings. I think the most famous one was the Stone case, where I was not an expert witness in that case, where the father was trying to get a ball at a Texas Ranger game, leaned over and fell over and died in front of his son. So you have those that are on the extreme, but the more common bread and butter ones that we see are going to be like dram shop issues with overservice of alcohol. You're going to have issues slip and fall, trip and fall. You're going to have medical condition issues that might become an issue, such as lack of service or inappropriate care of an individual. And then you're going to have the fights. And that's the one that I've probably been involved with the most over a number of years, have been these fight issues that are either in the parking lot. I've handled several death cases in parking lot, to attacks in bathrooms, to attacks in the stand, to even situations where I had a Bon Jovi concert case a couple of years ago involving someone who was just enjoying the concert, dancing away, having a good time. And there was a fight above them people tumbled down and landed on a person's neck who was dancing, rendering them paraplegic. They had nothing to do with the fight. It just started up above, and because of the gravity issue in that the elevated platform, they fell down on top of this individual. So there's a slew of different types of cases that we see, and the ones that we see most frequently are the ones that you'll see at any larger venue. For example, I've handled a number of escalator related issues, both on the defense side and on the plaintiff side. And that's something that could happen at an airport. It could happen anywhere. It's an issue of whether or not the maintenance was done correctly, whether or not something was overloaded, whether or not you have people that monitor the escalators, because unlike an airport where you have constant traffic, you might have an overload issue on some escalators with load in and load out of an event, and that could overload the system and that could cause it to break down. So those are the typical kind of things that we often see. But as I try to say, there's no typical kind of case because everyone's different. I think I've handled the most probably foul ball cases and what we call buffer zone cases. That is where you try to look at how much space you have between a given activity area and a potential obstruction, possibly an obstruction that is a hard obstruction like a wall. So, for example, I've done research with basketball. In basketball, you need at least 5.5 feet of space beyond the end line in order for someone to slow down and protect themselves. Even if you have padding, you need to have a certain amount of distance to stop. Now, there are some quote unquote standards, and I use the air quotes very liberally in this case, because where did those standards come from? So the National Federation of State High Schools, NCAA, says you have to have a minimum of 3 feet, but preferably 10 feet, at least at the high school level. Where did they come up with that number from? So that's ripe grounds for discussion and litigation, where you're going to have some experts saying, well, you need 10. Some people might say you need 6. Some people might say, well, if you have 3, that's fine. The more space you have, the better, but it's also based upon the venue and its history of what has happened there in the past. So if a venue has not had any issues for years and years and years, maybe it isn't the safest environment, but you've been lucky. Other times it could be that it is a safe environment. So it all depends upon the context, these types of cases.
And there's certainly no shortage of these incidents in the news. At the time we're recording this podcast, just a few days ago, there was an incident at Gillette Stadium with a New England Patriots fan that ended up dying after an altercation. And it's, perhaps debatable, or at least as of today, how much the actual altercation played in the death, but certainly a notable incident and kind of a mar on the industry. So, Professor, given the fact that there are so many of these incidents and so much potential for spectator and fan incidents at an event like this, what are some of your top tips, let's say your 3 top tips for a risk manager or those in charge at these venues for things that can be done from the facilities end on the front end to help reduce the likelihood of these events happening on the back end?
Document. That was 3, but in all seriousness, the top one is document. Having been involved in so many of these cases, I know years ago there was the mantra of let's not document so there's no paper trail. Now everyone has the paper trail. I can't tell you how many times I'm in cases now where I see pages and pages and pages of text messages, and you might think, oh, okay, this is innocuous. I'm sending a message, and that can come back and they'll put that in there in the record. And so you want to document that you're doing things correctly. And so if it doesn't look like it's going to be good on paper, then maybe it's not an issue of what you put on paper, but what is your conduct? And are you doing the right things? And so I can't tell you how many times in cases we go through and someone says, oh, we don't keep documents. Well, why not? And I think in our industry, it is so easy to keep and document everything because almost every larger venue has what's called an incident management system, an IMS, where they put everything down from a broken toilet seat, a broken fan seat, clogged drains, issues with food production. and medical issues and fights and ejections, all that's recorded. And so it's great to have the documentation, it's available, but you want to have consistency of terms. So when I was involved in the Stowe case, I went through all the incident management system recordings of all the different issues that had occurred at Dodger Stadium at the time. And there were a number of them, but also there were issues that, like a shooting in the parking lot. Now, it occurred after hours, but it did not make their list of incidents. That was all over the news, all over the paper. That's the kind of stuff where, even though it's not during an event, you want to keep it there, because if you're making decisions based upon information within the system and you don't have all the information, you're going to have an attorney that's going to jump all over that. So that becomes one thing. And also consistency in the terms. In the Stowe case, once again, there was an incident where a female police officer, her breasts were groped by a fan. Now, I would consider that battery. It's if she saw it coming, you could possibly have assault. But they called it fan interference. And so you're supposed to report assaults and stuff like that to the leagues. But if you have it categorized as fan interference, that might not make that list. So the league and everybody else will not have accurate information. So documentation is the number one thing that I try to highlight. The second is employee training. And this is one of the things where we often train employees, but there's a difference between training them and really training them. So oftentimes you have different crowd management providers that provide like a 8-hour, sometimes 6-hour, sometimes 4-hour training seminar once a year, maybe the start of a season. It might be a reorientation. It might be that you hope that everyone has a guard card, especially in a state where a guard card is required. So everyone should have a guard card or they shouldn't be used. And you think, okay, we've given them training. I look at it like military training, where they try training you and training you, breaking you of the bad habits and turning it into what we call muscle memory. That way you know instinctively what to do. You're trained to do it. We've been having issues post-COVID with getting enough people to work an event. But even when we have trouble getting people, if you have the right people in place, you're going to know it and the fans are going to know it. And that is one of the things that I keep seeing is a lack of vigilance on the HR side sometimes, where maybe you don't monitor employees. I just had a recent case where we got a plaintiff verdict against a major professional sport team league. Let me just put it at that. And one of the things they said is, well, we train our ushers to do X and we train them to do Y. And they played in front of the jury all this videotape of them not doing their job as ushers. Instead of doing what we call the roving T, going up and down and going side to side to monitor an area, they just stayed at the portals and just spent the whole time there. That's a lack of training. And to go along with training, you need proper equipment. They had walkie-talkies in that case, and the video from that section showed them trying to get a signal throughout the entire game. And so if you give them the tools and they can't utilize the tools, that's going to be problematic. So that's number 2. And number 3 is going to be the attention to detail issue. And that is inspecting the venue before an event and then making sure you have all the details in place so you're ready to run with the event. Larger events, I did all the defense work for MetLife Stadium for a number of years for a lot of their cases involving personal injury. And for almost every event, you have a 3-inch thick binder with all the documentation of everything that is going on for that event. And then you have all the preseason meetings, the if it's like the week before, all those meetings, the day of meetings, you get all the stakeholders together, and that's the attention to detail. And you want as many of those stakeholders that are relevant as possible in those meetings. And then you got to make sure, I call it the ACT approach, and it's in a number of my textbooks, that you want to, as much as possible, reflect on why you're doing risk management. Then you want to deflect as much as possible, which is contracts, waivers, indemnity clauses, whatever it is, deflect that as much as possible. Then you want to detect, which is a strategic way of trying to find things. I call it like strategic management, but the reverse. I call it worst case scenario planning, and trying to figure out, how do people die? And then trying to work backwards, how can you eliminate those elements? So after you detect things, you inspect, try to see if you have those issues, then you correct it, then you re-inspect, because just because you put down, okay, there's an issue, I need someone to go out there and to evaluate it and to correct it, doesn't mean that it actually was done. And now you're on notice that you found a problem, and did you actually correct it? And then after this whole process is done, you re-inspect. Reflect. Reflect is the last one. And the thing you want to reflect on is, did we do what we wanted to do? If our goal was to reduce injuries by 20%, if our goal was to meet industry standards, whatever it is, you want to reflect, did we do a good job? That all requires detail. And that's one of the, areas where we have control over that. We can control. We could do the tabletop exercises and do the what ifs, what if X, what if Y. Now, even with all that planning, there's going to be issues. For example, just a couple weeks ago, we had a woman who was able to bring a gun into a Major League Baseball game in Chicago. And supposedly, and we have to get all the facts still, she hid it in the folds of her fat, that she was a very large woman, and she was able to hide it, get into the venue, and then it went off in the middle of the game. And it unfortunately, a bullet hit a woman next to her and went through her thigh. So, how did that happen? Well, that's one of the things that you have to determine. Do we document that we do all the inspections, and that we, have the magnetometers working correctly, that we've trained people how to use the wands, and, all that kind of stuff? Do we document that? Do you actually train the people to do it? And then, did you have that in your plan? Are we going to, at least evaluate people that might be disabled, or people that might have other issues that might be, unfortunately, could compromise a venue? So those are kind of things. Those are three that I pulled off the top of my head that I think are relevant.
Well, that's all excellent advice, Professor. You mentioned that you have a lot of real world experience as being an expert witness in litigated cases involving fans and spectators and venues and facilities. Can you perhaps, let's talk a little bit more in depth about one of them where you were a defense expert in assisting the facility or the venue. Can you give us an example of one, what the issue was, and kind of where your analysis and expertise came in, and what you were able to look at and evaluate, and then that led to a good result for the facility?
That's such a tough question, because it's like, which kid do you love more, kind of thing. Because each one is so different, and you can pull so much interesting information from it. And since I'm about 50% plaintiff, 50% defense, I think some of the plaintiff cases are some of the more exciting ones, because you can often figure out, okay, this is what we need to do to educate the industry going forward, because here was a mishap that happened. But one that I really like involved a situation where it was University of Arizona versus University of Oregon, a nationally televised football game. And this went to trial. And the situation arose where University of Arizona was winning the game, and they were going to dethrone Oregon, which was in the top, I think, 3 in the nation at the time. And so it's a major win, national television. It's very similar to the defense work I did in the Wisconsin Camp Randall cases, where you have like the perfect storm, where you have national TV, you have excited fans, you have all these things going on. This was a similar case. And they saw all the students bunching up right at the front of the stands, that they were going to, when the clock ticked down to 0, they're going to rush in. And so the athletic director made the decision, let's open up the gates. And part of that is it was in consultation with other executives, with police, with fire, all the different key stakeholders to hopefully alleviate a potential crowd crush kind of issue. Now, there is a gap. It was a couple foot drop from the edge there to go onto the field. And so they opened it up. The fans stormed the field. While they were storming the field, you had a young kid who fell, broke his arm, and he sued. And he sued the university, the athletic director, all the different top officials in the athletic department, saying you guys were negligent for how you took care of this. Now, the issues with something like that is that these aren't necessarily things that are static. And what do I mean by that? That every situation is going to be different. So you can't just say, well, we did X previously, so that will always work. Because you don't know if the dynamics, every time dynamics might be different. It might be at one time it's a September or October game where people are wearing shorts. The next game that you have an issue like this might be December game where everyone's bundled up and traveling in a different manner, traveling with large families versus not traveling with large families, student sections versus general admission seating versus fixed seating. All these different variables come into play. In this situation, they felt the best strategy was to open up the gates and let the fans storm the field. And there was a lot of good rationale behind it because the number of entry points, the number of gates that they had that they could open up to alleviate pressure, to prevent a situation where there were more injuries. And in fact, it worked pretty well because there was only one injury that, was reported, and it was this kid who sued. Now, the plaintiffs were asking for a boatload of money. We actually had a decision that was against the University of Arizona. So the jury held against us, but they apportioned 90% of the fault to the plaintiff. So the final jury verdict was much less than what they were trying to settle the case for and what the plaintiffs were demanding. So it becomes one of these things where even though we lost, we won. Financially, we won. But it took a lot of effort, on the stand and a lot of time of athletic department personnel to, handle this kind of case because everyone was at trial and you had to have everyone there and all the preparation of these individuals beforehand and stuff like that. So the more we can preemptively prevent these kind of incidences, the more we can save our own time or the time of our clients.
Well, Professor, you are certainly a wealth of knowledge and information on these topics. You also have a number of free resources available to the public. Tell us a little bit about those.
So I even though I do expert witness work, I'm primarily a professor. And so I love it when they try to say, well, how much money do you make, from your expert witness testimony? And oftentimes my answer, which is 100% correct, is I make more from royalties of my textbooks than I do from expert witness services. So part of what we do as an academician is we're trying to train people. We're trying to make sure that we can educate as many people as possible that are out there. And so we try to provide as much resources as possible. And that could be, people flying me out to talk to groups. And, if you cover my expenses, I'm going to be there and helping train your frontline staff or things like that. But more directly, we have a facility that's put up by a Holt Hackney's publication company, and it's called Sports Facilities in the Law. And I know, Matt, you indicated you're going to be putting the link for everyone there. And that comes out 6 times a year. We have an advisory board, which is made up of folks that help manage Major League Baseball stadiums to top security personnel, people with NCAA experience, things like that. And we have articles from throughout the spectrum of the industry, all designed to either summarize cases or to provide risk management or other perspectives. And that's been going out for about 7 years now. So it's a very well-established newsletter, and it's free. So you can't beat the cost. We have about 1,000 subscribers, so it does very well, and it's a very informative piece, so we really enjoy that. Also, as I mentioned, training is one of the most critical elements for your frontline staff. If you take a look at a traditional NFL game, for example, you could have about 1,200 to 1,500 frontline staff working a game. That's a lot of people. That's a lot of training. And how do you do that effectively? So we created something at the University of West Florida called the Crowd Management Doctor. And I serve as the doctor. And we created a 17 module training program where these modules are all done by video, all designed to be about 15 minutes or so people could pull it up on YouTube and watch it. We're working on developing a testing protocol that people can watch them, then take an exam, and then become certified by it. But I think what I like the most is that anyone can watch it at any time. If you're having a pre-event meeting, you can tell your people, pull up your phone, watch this video, and it's going to be about medical issues, or it could be about fire safety, or it could be about screening individuals, whatever it might be. And we have more than just training modules. We have current events every couple of months. We do a new video of current events, and so that way it keeps people abreast of what's going on there. We have case studies. We have a bunch of different resources. It's all free. And so I can't stress that enough, that it's free. You can't beat that price. And that's all part of educating as many people as possible. I also have made available to those that are listening to or watching this podcast that I've developed a number of materials. One of them is a question document to use in a crowd management case, which lists hundreds and hundreds of questions that are critical to ask in a crowd management case, such as, what organizations are you a member of? What conferences do you go to? And it lists a wide variety of these things. So someone can say, well, do you go to this conference? Do you have this certification? Do you have X? Do you have Y? All these different questions that are designed, if you're on the plaintiff side, to go after somebody, or on the defense side, these are the kind of questions that might be asked of you. So this is how you have to prepare that. You have to understand these questions and respond to it. The last resources that I provided to Matt was a document called Lessons from Stowe. I was the expert witness in the Stowe case, which resulted in a $13 million verdict against the Los Angeles Dodgers back in 2013, if I'm not mistaken. And there's a number of lessons that were learned from that. And that's a document that is designed to present those, pieces of information, those kernels of nuggets designed for people working in facilities and those associated with them, to help them identify what are concerns that could hopefully protect them from having to face me as an expert witness on the plaintiff side, so to speak, kind of thing. So if that's of benefit, I hope that is something that you guys can utilize, and that you'll enjoy reading it, and that you'll find value in it.
Absolutely, Professor. Thank you for all of those free resources. Professor Gil Fried, thank you very much for joining us on the SERMAPod. Please come back and join us again sometime.
Sounds great. Thank you so much, and stay safe out there, everyone.